Emily, we have a new president, new administration, Trump 2.0. Today we are live here on Tuesday, every Tuesday from 5 p.m. to 6 p.m. Central Time. We do bring in immigration updates and we do take live questions where we do answer the questions. Emily, we're going to discuss mainly on the birthright citizenship, Emily, which was guaranteed in 14th Amendment that everybody who's born in birthright, whoever is born in the soil of United States, will be given a citizenship, though. And of course, according to a lot of people's assumption that if it's written in the Constitution, neither the president, which is considered to be an executive, nor even the parliament, which we call Congress in United States, can violate it unless they go and amend the birthright citizenship. Now, what happened? How did he put an executive order? Can you explain the legalities of it and on that, Emily?
Yeah, so he's not exactly eliminating the amendment, the 14th Amendment of the Constitution. He's trying to reinterpret how it's read. So there's a provision that basically says that you have to be both physically born in the US and subject to the jurisdiction of the United States. He's claiming that people who are undocumented are not subject to the jurisdiction of the United States and therefore should not be considered citizens based on being born here. And he's directing federal agencies starting 30 days from now to not process applications for passports and social security numbers of people who are born here. Now, he takes it even further, not even talking about just undocumented immigrants, but he's also saying that people who are here on temporary visas also are not subject to the jurisdiction of the United States, which is a bit laughable since every person here on a temporary visa is filing taxes. Surely you wouldn't be filing taxes if you weren't subject to the jurisdiction of the United States. You can be arrested. You had to go for a visa interview. You had to be fingerprinted, photographed, file applications. Obviously, you're subject to the jurisdiction of this country. So it's a bit laughable. We have already seen lawsuits filed to block it, which should ultimately be successful. I think we're up to 18 states have already filed a lawsuit along with the ACLU, basically arguing that this has been the law of the land forever. There's already been Supreme Court case confirming this is how we interpret the amendment. There's really no way that the president has this power.
So, Emily, we will go to the legalities later on, though, because of the constitutionality. Of course, everybody knows that we are also working behind to get this overturned. But at this point of time, the implementation of this one is 30 days from the time the executive order has been signed, which is on January 20th. So the 30 days falls on February 19th. Anybody who's born on or after February 19th will not be considered a U.S. citizen, at least according to the executive order, though. That means if either one of the parent is not a U.S. citizen or green card holder, the child will not be given U.S. citizenship automatically. So according to the executive order, so if either of the parents are not green card holder or U.S. citizens, they will not be given citizen automatically, as it used to be practiced, where if the person is born in the United States, you just take the birth certificate, you don't even go to any citizenship, USCIS, you just go to the post office or you go to the passport office and you show the birth certificate and you get the passport right now. And that's good enough for the child forever to stay in the United States, work and do whatever the U.S. citizens are there. They can even become the president of the United States too, if they are born here in the United States. Now, of course, the new interpretation is that they are not going to be given automatic U.S. citizenship if either of the parents are not green card holders or citizens. We've been telling before, because what he was promising in the elections, though, he said only illegal people, children, will not be given citizenship, he said. However, in the website of Donald Trump, he always mentioned that it's going to be anybody's whose one of the parent is not a green card holder or U.S. citizen. We have presented this several times before. And now when we see the executive order, that particular language is there. that even for those people who are legally in United States, who got the visa legally, entered legally into United States, working legally in United States, their children also will not be given the automatic citizenship. We have a lot of questions that came in. I've written an article answering about almost 40 questions. If you want to, I've provided a link at the bottom. You guys can click on that. It has answers for about 40 questions, who, why, and how this has been applicable. People have questions like, for example, if I'm an adjustment of status EAD, and I have a child born after February 19, will the child will be considered to be automatic citizen according to the executive order? The answer is no. The child will not be considered to be the automatic citizen, at least under the executive law, executive order. Emily. We are going to update you with regards to the lawsuits filed later on. As Emily has pointed out, approximately 18 states. What you mean by states is like, California is a state. Like that 18 states out of the 50 states have filed a lawsuit against the executive order. And there are a lot of cities that have also filed lawsuits. So most probably there will be a class action on it. We don't know how long it's going to take for the Supreme Court. It will go to Supreme Court, Emily. Do you have any doubt? I can't hear you, Emily. I can't hear you, Emily. Emily, I can't hear you. We're having some technical difficulties. I can't hear Emily. There is also another 200 executive orders signed by the Trump administration. So out of those things, I did summarize those things that are applicable. Approximately around 11 to 12 executive orders are touching the immigration issues for the non-immigrant visas who are legally in the United States. And that article is also provided in there, even though some of them are just directly addressing only unlawfully present here people. However, they will indirectly affect us. The reason they will indirectly affect us is because there will be extreme venting that will be going on against the immigrants under the new administration. So we will see a lot of those things happening in the coming months, where a lot of vetting, a lot of screening will be happening at the port of entry. There'll be a lot of at the visa stamping place. Also, there'll be a lot of screening that will happen. There'll be a lot of delays, denials, and also 221Gs that will be issued at the consulate. So this is executive orders, even though not just the birthright citizenship, the other things will also affect the immigration community, the non-immigrant visa community that are legally in the United States. It will affect them too. I know that a lot of people are scared at this point of time. We recommend strongly to keep coming to our YouTube channel every week. Tuesday, we do bring in for 1 hour. We update the things for 1 hour, and we take the live questions here so that people can get the real answers, though. I'm going to try to go to question and answers for those people who are asking questions while I'll be waiting for Emily. While the Karthik is asking about questions about what is the timeline that to be expect that executive order to be challenged for the courts to be taken any action, it's going to be very urgently taken, though, either by the district courts or the circuit court or even the Supreme Court, because there'll be a lot of cases filed. As I was pointing out, approximately around 18 states have filed the cases. So it will be taken seriously. It may come up in front of the Supreme Court very soon, but we have to see how the Supreme Court is going to side with. The question Krishna is asking that 5 out of 9 Supreme Court judges are in favor of some. So really, can we trust the legal system? Well, favor of, I think so that the Supreme Court justices are appointed for life. They are not appointed just because they're appointed by the Trump administration doesn't mean that they'll be in favor of everything what Trump takes, though. They will have to go with the Constitution. That is my belief. I do trust the legal system in the United States. That's definitely a thing that I will look into it. If both people are employed in adjustment of status and prior to date regress, can the child get any status to in USA? These questions will be coming in. If they are not being given a citizenship, what will happen to the children, though? Because we did not have to answer this question ever before. The USCIS will come up soon with regards to the process that will be involved in if the child is born in the United States and they are not a US citizen. What is the process for it? The USCIS will come up very soon. Most probably, they will allow people to change the status in the United States. They may allow people to apply for the adjustment of status. One thing people need to be aware of is that if the child is under 18 years old, especially this gentleman is asking a question, he's on I-485 EADs and both the parents do not have non-immigrant status. So the child is born, he cannot be a US citizen and he cannot be on a non-immigrant visa. The one good news is that a child under 18 does not accumulate the unlawful presence, though. That means that there is a law that says that if somebody is unlawfully present in the United States for 180 days, there is a 3-year bar. And if it is 365 days, there is a 10-year bar. But the kids under 18 don't accumulate it. So there is no penalty for them at this point of time. Emily, you're okay?
Hopefully. Can you hear me now?
Yeah. Yeah, I can hear you now.
Okay. Switched laptops. Always have a backup.
And people who are on H1 and H4, F1 or L1, if their children are born, though, they will not accumulate the unlawful presence. Don't be fearful about that aspect, though. They will be given opportunity to change the status. If not, whenever the child is a little bit later, they will be allowed to go outside the country and get the stamping. I'm not worried about that aspect, though. But what I'm worried about is that approximately, we have a limitation on green cards for the employment based. That is for Indian nationals, particularly, it's only for Indian nationals, it's only out of 140,000, only 7%. Where would these kids will be added? Will they be added in the Indian quota? That means that we're going to have lesser number of green cards available for Indian nationals, because most of the time previously these kids didn't used to be counted towards the number and they were getting the citizenship. So the amount of green cards that are going to be given for the employment based will be eroded to a greater extent if the children were not given citizenship. Emily, go ahead.
So I don't know if you wanted to talk now about some of the other executive orders. You know, there were 42 of them that were published just in overnight. And so we tried to go through them as quickly as possible. Not all of them deal with immigration, but a number of them do. And going through that, there's quite a few that they don't sound on their face like they're talking about legal immigration, but they do still have some impact there. Particularly, there's one that talks about basically this extreme vetting and to require, vetting of all people to be the United States. That is going to be translated into, we're going to do more administrative processing at the consulates for visa stamping. We're going to require more interviews for the visa stamping, maybe reduce the number of drop box or eliminate. We're going to issue more RFEs. We're going to require interviews for green card applications. All of this is just meant to delay everything and gum up the system to make it totally unworkable so that people get frustrated and give up. So I think that's what we are in for over the next 4 years. Everything's going to take longer. The whole thing is going to be much more frustrating. There's going to be increased RFEs, increased denials, just because of this one little statement about extreme vetting. And then there's another very small provision that tells the agencies to issue a report in the next couple of months where they review all visa categories to determine whether there's any particular category that harms the national interest of the United States. I think that particular provision is likely directed more towards another Muslim ban, which was done before. But it very easily, I could see Stephen Miller telling Trump, hey, the H-1B visa is harming US workers and we need to protect our national interest. Let's restrict H-1B visas going forward. I do see them using that same 212F to block H&L visas, just like they did before, using COVID and the economy as the reason for it then. Now they may do the same thing using this national interest type of argument as to why they're trying to do it. And I think also this time around, the Trump administration, number one, they're moving fast. They're very organized, and they've learned from some of the mistakes that they made in the prior administration that caused some of these executive orders to get shot down. So it's definitely, all of these are likely to face challenges in court. But in the meantime, we can expect everything to just take longer and be more difficult to make it through.
Emily, after I published the article, though, I've been conducting Zoom calls. As you know, we do have a daily Zoom call. People can join. We've been doing it from 2012, approximately 13 years, every single day. Emily, I have this interesting question and debate that I want to have it. And maybe I have a little bit better knowledge than you have, because I'm a lawyer from India. With the question that is asked, this gentleman is asking the question, he's expecting a baby in March, congrats. And this is Yashwant Kumar, he's expecting to travel to India in May. Now, the question is that because Yashwant, because you are an Indian national, which I'm assuming, or your wife is an Indian national, your child will be given Indian passport though. And based on the Indian passport, you can travel and you can get the H-1B visa for your child and come back into the United States. H-1 visa for your child and come back into the United States. I don't have a problem with that. But what I do have a problem is, while the courts are taking a longer time, if the child gets the Indian passport, which India does not have a dual citizenship, what if the court comes in favor of us and then they say, hey, you know, this kid is not under our jurisdiction. He already got the Indian passport.
Mm-hmm. Yeah, definitely not a good time to travel.
Yeah, I'm a bit cautious because they're not accumulating the unlawful presence. What's the hurry to get the Indian passport at this point of time? And maybe lose the entire chance of becoming a US citizen at a later date until we get the clear directions from the court this way or that way, though. So I'm a bit hesitant. I probably will tell the people not to apply for the Indian passport at all. That's what I would recommend at this point of time. But I want you to keep watching our YouTube channel. I may change my opinion, though, as things develop, though. Don't be in a hurry in taking the kid to India at this point of time. Don't be in a hurry in getting the Indian passport. I still want to argue to get the US passport for your children at this point of time. Let the time take it, and it's not going to harm them in the long run, at least the immigration provisions that exist there. Now, going back to your topic, Emily, that you are telling that Stephen Miller, we already see Vivek Ramaswamy out of the team of Trump. Elon Musk is still there. We don't know how long he's going to be there. But they're not in charge of immigration. Neither Vivek Ramaswamy nor Elon Musk are in charge of immigration. The people who are in charge of immigration is Stephen Miller and probably Steve Bannon to an extent. Now, you're telling that can the H1 and H4 be stopped by an executive order?
Yeah, absolutely. They've done it before. INA 212F is a particular section of the law that was passed by Congress that gives the power to the president to restrict visas if there's a compelling reason to do so. And so he used that particular provision previously to block people from China coming in during COVID, to block with the Muslim ban, and then later to specifically block H-1B and L-1 visas from being issued. A lot of people got stuck outside the US, had no way to get a new visa to come back. They had to qualify for some sort of exemption. So yes, we've actually been through this before. And so it is very possible that we will see it again, but the reasoning for it will be different. It will be more in line with these particular visa categories are somehow harming our national interest under this particular executive order.
Anything about advanced parole travel is the question that is coming from Anna Stevens. We haven't seen anything in the executive order, at least right now, restricting the advanced parole people to travel, though. So there is no travel ban at this point of time on the H-1B, H-4 or advanced parole. Right. We don't know if anything else will pop up. This is only the first day that he's been in power. But at this point of time, we don't see any travel ban for the people. A lot of questions are coming with regards to one parent Indian, the other is the rest of the world. What is the best course for the baby? Is it giving birth? And the July is the due date. Definitely traveling when the pregnant lady is about first or second or third trimester. I definitely not recommend, if you're already in USA on a non-immigrant work visa, definitely not to travel. And also, I believe, though, at this point of time, which I may change my mind, but let me not give advice to you guys. Let me actually tell, if I were you at this point of time, if my wife is pregnant and she's going to give a birth, assuming that I'm an H-1B and my wife is an H-4 or vice versa, and my wife is going to give a birth on July 1st of 2025, I am going to have my baby delivered in USA, irrespective of the executive order, because there may be some, this may be thrown out. There's a good chance for it. Even if this may not be thrown out, I would not try to take my wife outside the country and have it delivered, my baby outside the country. That is my opinion at this point of time. And I'm not going to tell you guys what to do. I'm just going to tell what I would do if I were you.
All right, other questions. This one comes from Sai. Should H-1B holders or any visa categories be worried about the Laken-Riley Act? Yeah, so this particular provision is a bill. So it was introduced in the House last week and it passed in the House. Then it went to the Senate early this week and passed the Senate. The version that passed the Senate has an amendment added to it. So it does have to go back to the House, but it will very likely pass in the House and be signed by the president. So what exactly does it do? On its face, it is meant to require ICE to detain unlawful immigrants who have committed certain crimes, like or have been arrested for certain crimes, not even convicted yet or committed, but arrested. So theft, burglary, and then this new amendment added crimes of violence to that. So it sounds like not a bad idea on its face. We want criminals to be off the streets. However, it adds a provision that allows any state attorney general, so like the state of Texas, can sue the federal government if they have been harmed in some way by an undocumented immigrant who is not detained, in order to force the government to start detaining people. On top of that, the state can sue the federal government and say, hey, this particular country is not accepting all of the deportees back into their country. And for that reason, you need to stop accepting any visas from that country. So the state of Texas could say, India is not accepting all of their removals, people who've been deported, and because of that, India should no longer be given visas, regardless of what any other state has to say about it, regardless of what the federal government has to say about it. So that's one of the big problems with it, is it gives this power to an individual state to possibly block visas from any one country. And on top of that, where visa holders could run into trouble, obviously, if you don't commit any crimes, if you're not arrested, you don't have anything to worry about on this particular act. But let's say you do get caught shoplifting and you happen to be in a situation where maybe you have filed a change of status and your previous I-94 has expired. So on paper, it looks like you have overstayed your visa, even though you've got this pending change of status. You all know how it is when you go to get your driver's license renewed, how much hassle they give you if you don't have the approval notice because you've got something pending. Officer trying to figure out whether you are lawfully in this country or not in the event that you get arrested. So that's where the Lake and Riley Act is problematic for legal immigrants.
Yeah, it's going to be a problem when the EAD extension is pending, where we know the 540-day rules is there. When the H4 and the H1B extension is pending, and especially with the suspend the premium processing. And they already said to us last week that is the last time that hey, when the H1 and H4 and EAD have been filed together, they may not approve the H4 and EAD together. So that's a problematic thing. So definitely these things are very hard for immigration lawyers to understand, and a police officer who is looking into criminal aspects of it, understanding the immigration papers is very tough. They becoming immigration lawyers is very tough for it. People are asking questions. I have a visa stamping and H1B. Can I travel right now? At this point of time, we do not have any executive order that is preventing you to travel outside the country. But if there is any deficiencies in your H1B or at the time of OPT or STEM extension, I definitely will consult an immigration lawyer to make sure everything is okay before you travel outside the country.
A couple of people had questions about the new version of the I-129 form that took effect on January 17th. I heard USCIS no longer accepts the old version of the form and will reject petitions using that old version. Yes, that is correct. So this is based on the January 17th regulation that took effect. And in order to implement that, they had to revise the I-129 form to add some additional questions. So at the same time, they provided no grace period for switching over to the new form. So if your employer prepared an H-1B petition to file last week using the old version of the form, but it did not get delivered to USCIS properly until Friday of last week, it will be rejected. They'll need to re-prepare that petition using the new version of the form.
Emily, I have some debates that I want to discuss about. Some of the people are asking, and as we do a lot of we are not YouTubers, guys. Please note down, we are practitioners. We have immigration practice. The YouTube is not our main thing. Our social media is not our thing. We both are partners, and we've been. Our law firm has been established in 1997, and Emily has been associated with this law firm from 2003. She is the managing partner. I'm the founder of this organization. There may be a lot of YouTubers, but we are practicing immigration lawyers. We get a lot of cases. Now, Emily, the question that is asked is, since the new administration has been elected, are we noticing any odd things going on? He's asking more 221Gs from the Dropbox, or any odd denials, port of entry things that we have been noticing though. Now, the administration came in yesterday, so experience for us is only 1 day right now. But before, it's been about 2 months, this administration got elected, but came into power only yesterday.
Yeah, we actually have seen some changes. We've seen delays with premium processing, particularly for I-140s in the EB1 and EB2 NIW categories, going beyond the required processing time for those. New and more RFEs on those particular categories. And then the newest thing we're seeing is referencing the FLSA, which is the Fair Labor Standards Act. This is the nationwide law that governs what the minimum wage is for hourly workers that has to be paid. It governs whether employers have to provide you with certain benefits, and it also governs the whether a company has to pay when a person is an intern. And all of a sudden, the USCIS is claiming that unpaid internships during OPT time are somehow not meeting the requirements of the Fair Labor Standards Act, and therefore that unpaid internship experience counts as unemployment time, and people are exceeding the unemployment limit on OPT. We've seen this pop up within the last couple of weeks, and just today, receiving more of those types of denials. They're denying the change of status from F1 and OPT to some other visa category, typically H-1B. So that's definitely something to watch out for. They are kind of looking at these more holistically, I guess, trying to interpret other agency statutes. Like the FLSA has nothing to do with USCIS. It's a more under Department of Labor. They're charged with enforcing it, but USCIS is doing it through denials.
Question from Banu. His wife is a green card holder, and of course she's going to carry the passport and green card. Is she expected to get any trouble? At this point of time, no restriction, none whatsoever at all for your wife to travel on a green card.
Sunpath says, are there any executive orders signed that impact the 485 adjustment of status process based on employment? Nothing specifically. However, that extreme vetting type of executive order is likely to impact 485 adjustment of status. I think that probably, as we saw before, they will require interviews for all 485 applicants. That slowed everything down. The field offices are not as familiar with employment-based immigration, and we saw a lot of unnecessary denials and unnecessary notice of intent to deny and RFEs in employment-based cases that typically don't happen. So I do expect that to happen going forward.
PSR is asking the question from YouTube. Birthright citizenship for the kids who are born to I-140 holders. The answer is no. They won't have a birthright, at least according to the executive order, unless something is changed, though, at this point of time. Either one of the parent must be either a permanent resident, that means green card holder according to us, or the citizen, either one of the parents. It doesn't have to be both, but at least one of the parent has to be. If none of the parent is a green card holder or a U.S. citizen, then the child will not be given citizenship according to the executive order.
Allah says, my student visa expired the last week of December, and I'm planning to visit my home country in Algeria. Is it safe to travel and come to the U.S., or might there be other issues? Now is not a safe time to travel because you don't have a valid visa stamp. So before you can come back, you're going to have to visit the consulate, get the new visa stamped in your passport. There may be some sort of travel ban implemented that won't allow you to get a new visa, or you may go through additional processing, administrative processing, in order to be issued that new visa under this extreme vetting. And you could be stuck there for many months and miss your classes. So unless it's absolutely life or death reason to travel, I would not recommend traveling if you have an expired visa right now.
People are having questions with regards to my child is born and 2 years ago got the passport. At this point of time, the executive order does only cover from the children born on February 19th or afterwards, but not of 2025. If your child is born before he already has a U.S. passport, nothing says that he's not a U.S. citizen. He's a U.S. citizen at this point of time. So definitely it's only starting from February 19th onwards, not before though.
Guru says, my AOS 485 was filed December 12th, 2024. Will this executive order impact the already filed petition? Yes, they do. So it's not based on the date of filing when it comes to an executive order. It's when they're going to adjudicate your application, what is the law at that time, including any executive orders. So it's very possible you might be called in for an interview where you wouldn't have before. You might have to be fingerprinted again if you haven't, if they were trying to reuse your fingerprints from before. The process might take longer.
Can you file a lawsuit on federal government on the immigration harassments over hardworking people from many countries? This is from Post-Industrial Economy from YouTube. This gentleman is asking the question. In the Trump 1.0, though, we have seen a lot of harassment for the H-1Bs, where we have seen H-1Bs getting approval only for 1 year extensions, sometimes even though they're eligible for 3 years, sometimes even 6 month extensions. Premium processing was being suspended. H1, H4, and EAD, when filed together, were not being approved together. They have introduced biometrics for H4s, which delayed unnecessarily. They have tried to harass us in whichever possible way they can harass us. Believe me on that. We didn't used to have a litigation team at all for us before the Trump 1.0, though. We didn't have any option. I mean, we used to get a H-1B denial once every month, or maybe a couple of months, we used to get one H-1B denial. And then we used to speak with the employer, the employee, employee's wife, employee's uncle in the conference call. And of course, there is a strategy we use in responding to the RFE. Everybody has a different strategy. It was a very tough deal to deal with all those people, but we have to deal with once every quarter or once every 2, 3 months. We have to deal like that. But once Trump 1.0 came in, believe me or not, in our office, somewhere in 2017 and 2018, there was not a single day, every single day, we got a H-1B denial. Every single day. I'm sorry to say that, but our performance was like that. Every single day, we got a denial. And and people, they just adjusted. It was not that big of a deal for us to even speak with an individual why the H-1B got denied. They wouldn't even used to refile the application, make them go to India, get the stamping, and come back. So it is, and we started suing the USCIS. That's when we started getting better results. We sued USCIS in a class action on behalf of you, and we got H1 and H4 and EAD. They have, when we file, they have to approve it together. We got those things. We went to courts for getting the shorter H1B approval. The court reversed the 2018 memo that they passed, and then we started getting 3 years H1B approvals after that. Yes, court will probably the source for us, and the court will be for us in the Trump 2.0. It may not be as easier as it was in Trump 1.0 to go to the court and get it in our favor, but yeah, courts will be the source for us at this point of time to sue if there is any denial, if there is a shorter approval, or if there is a delay in application. That is when we can go to the court at this. So people who are here in United States need to prepare if you want to stay in United States to go to court. A lot of people ask the question, will there be any harassment because we go to court? We have not seen it. Technically, they cannot harass people if you go to court. Court is one of the holiest places in the democratic countries. So just like, Makkah is for Muslims, Pope is for Christians, and the temple is for Hindus. For the democratic countries, court is a very sacred place. Going there is not considered to be bad by anybody.
Alok says, can you share any news on H4 and H4 EAD? Yes, so we do have the settlement agreement that required USCIS to adjudicate the H-1B, H4, and H4 EAD filed together. If they were all filed together in premium processing, they were supposed to approve them together. That settlement agreement ended last week. And so from our side, we had typically been reaching out to the USCIS attorney when cases were not following the settlement agreement, and we were able to get them adjudicated properly. As of this week, we were told, nope, you need to just contact USCIS, which means going through the regular customer service because premium processing won't listen to a word you have to say. We are seeing H4s and H4 EADs being separated from the H-1B, from being separated from each other. We're seeing cases where a change of status to H4, it gets approved and the EAD gets delayed. So the person has to stop working if they were on H-1B previously. So we're kind of going back to how things were when the Trump administration had implemented that biometrics requirement, even though there's no biometrics added yet.
Will the adjudication of the advance parole EADs, will it be an issue? We are not expecting that as an issue. Advance parole is already delayed by 17 or 18 months for some of the cases. EAD, we already have the 540 days, which is not touched yet. And that was put in a regulatory format. So I don't think so. This guy can just do an executive order, but we never know what provisions he's going to use. If he can bypass the amendment, though, I mean, what regulations he can even try to see he can bypass. But of course, we'll have to go to court if something happens. People are asking questions with regards to I'm an adjustment of status EAD. I don't have an H1B. Is it safe under the period, though? I personally feel having one EAD is more safer than actually having H1B and EAD together. And you know that under the new provisions for H1B, there is for if you're working for a smaller company, there is an FTNS visit. There is a compulsory FTNS visit. There's a lot more scrutiny for the H1B. If something happens on the H1B, it may affect your adjustment of status. That is my personal belief, though. I personally, when I had a EAD and non-immigrant status, I let my non-immigrant status go. This is a long time ago. Given a chance again, if I am in that status, though, I'm going to get the non-immigrant status go when I have an EAD. There'll be a lot lesser issues according to me. I'm not going to advise what you have to do. I'm going to just tell what I would do if I were you.
Nagaraj from X says, when H1 and H4 is stopped, would it only be new visas or would it also include current H1B visas who are under extension? So when we are talking about an H1B or an L1 ban, a visa ban, it always comes under 212F of the INA. That particular provision talks about visas being issued at the consulate. So when we say there's going to be a potential ban on H-1B visas, we're talking about the stamp that's in your passport that allows you to get into the US. Whether you are applying for the first time or whether it's a renewal didn't matter before. No exceptions for people who already had the visa in the past. So they can just point blank block all consulates from issuing new or extension or renewal visas for H-1B or H-4, L1, L2 holders. What it doesn't allow them to do, 212F, it doesn't allow them to block applications from being filed with USCIS. So even though there may have been an H-1B and an L1 ban in the prior Trump administration, for those who are in the US, we could still file a change of status to H-1B for their very first H-1B. The lottery went through as normal. We could still file extensions for H-1, extensions for H-4. So none of that was impacted by a H or L visa ban. We're literally talking about the visa stamp in your passport that gets blocked at the consulate.
Is it possible for the USCIS can revoke the 5 years approved EAD in advance parole? Unless the 485 is been denied, I don't see how they will revoke the EAD in advance parole. Very unlikely. I would not think that they will do, and I don't think so that is in the pipeline at this point of time, though.
Vemsi says, will premium processing be stopped for all petitions? They have the power to do that. We saw it before for certain petitions when USCIS claimed that they could not process them timely, or they were facing high levels of filings and things like that to where they couldn't vet applications properly. Yeah, they blocked premium processing. I don't think I've ever seen it where they blocked it for all eligible cases for premium processing across the board all at once. It's always been for cap subject H-1Bs, it was blocked for a time. For extensions of H-1Bs, it was separately blocked for a time. For I-140s, it was blocked for a time. But none of that was all at the same time in the past. I don't know if they would do anything differently this time around. But yeah, they can definitely stop premium processing.
This gentleman has an I-140 approval and his passport stamping is until February 2026. Do you expect any problem in him traveling? Right now, no restriction is there for you to travel until February 2026. And there's another gentleman, he has a passport stamping and he is having a cruise travel. Should he cancel? I would say that if I were you, I would not cancel. Since you already have a stamping in the passport, and I'm assuming that you have on H1B and H4, I don't see a reason why you should cancel the trip at this point of time.
Lex says, I changed my employer last year and applied for the new perm. Once my application is approved, do you recommend filing an EB2 or EB3 category? My I-140 with my previous employer is EB2. Well, right now, EB3 is further advanced than EB2, but they do flip-flop from time to time. So the best thing to do if your employer is willing is to file both. It's very easy to do. You can do them at the same time, and that way you're covered whichever way it goes. If the employer is not willing to do that, I suppose you could file an EB3 now, since that date appears to be more ahead and seems like it might stay more ahead. But of course, if it flip-flops again, your employer will have to file another I-140 to take advantage of it in the future.
Emily, this gentleman, Hello World Real Human, has this question. His wife is due in May of 2025 for childbirth. Does he need to take the court case individually, or is he not already covered by the 18 states and a lot of other cases that have been filed? Most probably, it will be a class action suit, which will be affecting, though. Do you think so that individuals have to file the court cases separately?
I don't think so. I think although we've got certain cases, cities filing, certain states filing, this is ultimately going to be teed up for a nationwide injunction and hopefully nationwide blocking of it when the final decision is made, which would cover everyone, even regardless of whether you were involved in the lawsuit or not.
Amir Jahargar has this question. If the child is born and doesn't get the US and gets the H4, can it be charged under cross-chargeability? I just want to tell you what cross-chargeability is. Let's say, for example, if you're born in India, and let's say your wife is born in UAE, you can claim, even though you are the main applicant for the I-140, you can claim your wife's birth for the cross-chargeability. And based on the rest of the world, you can file the 485 application if the priority date for the UAE is correct. He's asking if the child is born in USA, can we do the same thing? Unfortunately, this cross-chargeability does not apply for the children. It only applies for the spouse. So no cross-chargeability in this case.
Someone had a question. They were on STEM OPT for F1 and sounded like maybe they had not been paid by their employer for 2 months and wondering if it's safe to travel. No, I would not recommend it at this time. Even if you have a valid visa stamp under the STEM OPT, it does have to be paid employment for at least 20 hours per week. And when you're at CBP coming in, they do have the authority to ask you to unlock your phone and ask you to show them bank statements and ask them to show you emails. And they're able to figure out very easily that maybe you might not be in compliance and block your entry and send you back through expedited removal. So I think anyone who has any issue with their previous status or their current status needs to be careful with traveling right now.
People are asking questions. Will there be a delay in the 485? Will there be deny in the citizenship application? There will be delays in everything possible you can expect. There will be delays with the USCIS adjudicating the applications. There will be delay in the passport stampings. There will be delay in adjustment of status. There will be delay in the citizenship application. Now, there are 200 executive orders that have been signed, approximately around 50, 60 have been published. I went through each and every of those things, and I went through those things that are applicable to the immigration and studied it. And I will tell you some of the executive orders, even though they don't sound like that, how they will affect it. One, of course, we covered the citizenship application, citizenship thing very detailed. We don't have to go through that. The second thing that there are a couple of other things that they have covered. It is called foreign terrorist and national security public safety threats. Even though that is completely not applicable to you guys, they will use it to delay in getting the visa stamping, entering into the United States, getting his All those things as I addressed, and there is called uh, guaranteeing the state's protection against invasion. That's an executive order. I know it sounds, what is invasion? What do we have to do with it? Well, it meant for illegal immigrants mostly, but they will also apply that one to delay the things for us. Protection, previously the executive order was guaranteeing the state's protection against invasion. And there is another executive order called protecting the American people against invasion. Even that will actually delay the things what I addressed about stamping, USCIS, everything, extensions and everything. Securing our borders, there is another executive order that also will affect realigning the United States refugee admission program. This may even delay our things too. Military role in protecting territorial integrity of United States. What does this has to do with non-immigrants? Well, now the military people are going to come and inspect the things. They may be involved in at the port of entry. They may be involved at the border. A lot of the trained immigration people cannot understand the immigration. How would these military people understand what an immigration law is? So that will delay the things still. Of course, there is called Americans' first priorities. This may also, to some extent, delay the adjudication of the non-immigrant visas, and also to get some jobs in federal contracting jobs also may become very tougher for the foreign nationals. So these are all the executive orders that I covered. There's an article I published on it. You can look into an RN Law group in the blog. How it's going to affect, you can read more in detail.
Another question that came up on X was, what does the timeline look like for a court to issue a decision about this birthright citizenship case? So I think we look at, the February 20th, 2025 is a bit of a deadline, because that's when it ultimately is set to take effect for anyone born after that date. So I think with any lawsuit that's been filed right now, they are certainly going to be asking for an injunction, and courts, knowing that February 20th is that deadline, they're likely to start the hearings process and go through all that process. I would expect or anticipate that we would see an injunction issued by February 20th. Of course, there's no guarantees in that, but I do think everyone understands the importance of this case. And so that's just going to be the first step, though. The actual final decision of a court. So the purpose of the injunction is just to block it from taking effect while the sides hash out the merits of the case itself. To give you an idea, we're still waiting on decisions for the DACA program that's been around for years, over a decade. The Fifth Circuit just came out with a decision last week on it. So it may take 4 years. It may take longer for them to come to a final decision. This has to weave its way through multi-levels of court. It goes back and forth throughout that process. So it's not going to be a fast final decision, but I do think we'll see a fast injunction, hopefully by February 20th.
Two things I want to debate with you, Emily. One thing, this question is coming from SVP Sunil. If the Trump imposes any travel ban, will there be any more green cards given to the employment? Because most of the things what you said was that the consulates might be restricted in granting the visas. Most of the employment-based green cards are here in the United States, and the family-based are through the consular processing. Yes, it is possible, even if there is no travel ban. Remember all the invasion and the security thing issues, and they running through all those new security provisions may delay the family thing. Yes, there is a possibility that the employment-based green cards could get extra green cards. Any comments on that, Emily?
I think, yes, that's a possibility that extra green cards might be available. But as we saw in prior years, having all those extra green cards does not mean they will actually go anywhere. How many got wasted in 2022 2020,
Yeah, but still,
80,000.
Emily, they still employment these green card people got benefited overall, I would say.
They did, but now when we're talking about more extreme vetting, slowing down the green card process, yeah, there's going to be potentially some benefit, but not. I don't think that's something we should hope for as a way to get additional green cards.
I have this other question, Emily, that the DOG, which Elon Musk is in charge of, they want to cut the bureaucracy. And we know we don't know about other government agencies, but I've been working with this government agency from past 30 years, Emily. It's been 1995. I'm a lawyer now. It's been 30 years. There is so much wastage in this agency. There is no technologically very backward agency. This agency is. The adjudication system is very bad. Could Dodge involve in this one and make it more efficient and faster? I think so, no. But yeah, go ahead.
I sure hope so. I mean, I came to this firm in 2003, and the big buzzword from the Immigration Service is at that time was transformation, if you remember. They were going to transform everything digitally, and everything was going to be electronic. That was in 2003. We are now in 2025, and they have barely scratched the surface of transforming things and allowing us to file online and all those sorts of things. So yeah, it would be great if the Department of Government Efficiency would look into USCIS, would look into their efficiency, their productivity, how they're issuing receipt notices. I mean, it shouldn't take 3 months to get a receipt notice. Come on. There are definitely inefficiencies there that can be improved. Now, is that going to be top of their planning? Maybe not. Maybe they're looking more at the IRS first and other agencies, but maybe we'll see some benefit from that.
Emily, one thing I noticed that when in 2000, when Bush came to power, though, the 485 applications, which used to take about 3 years, were taking only 3 months to get it approved in 2001 and 2002, Emily. What happened was that President Bush gave an ultimatum that, hey, bring the processing times down. So and he gave them 6 months to bring the processing times down. You know how the lazy officers are. They didn't do anything. In the 6 months, the processing times went up. You know what he did? He fired all the district directors. He fired them. And he didn't fire them immediately. By this letter, I'm firing all district directors 6 months from now. Then what happened was that the processing time, believe me, there were interviews on Sunday. People were telling, I have to go to church. No, you have to go for the interview. Sundays, Saturdays, every interview was there. And believe me, the processing time came down so significantly in that 6 months. He still fired them, though. That's a different issue. The processing time gave 6 months. He did it. Could that happen? That if Elon Musk were been given ultimate authority, could that happen? If Elon Musk were been given power on this one, he would definitely bring it down to even 1-2 months, though. We have to beg him that, hey, don't do it in 2 months. Let's do it, especially for adjustment of status and certain other things, though. He could, but the only problem here is that it's not Elon Musk who's in charge of immigration. It is Stephen Miller who is in charge of this one. He is the immigration advisor, not Elon Musk. Elon Musk is overall government in charge thing. And particularly, Elon Musk want to reduce the amount of money that the government is getting wasted. Here, this is a self-funded thing. It's not something that government is spending the money. So I don't know what interest Elon Musk will be allowed to have it in this one and to try to reduce this one. While Stephen Miller, on the other hand, wants to delay everything possible. We have seen him last time as an advisor. We're going to see him again. He doesn't want these things to be done faster.
Another question that popped up is about the H4 EAD and the potential for it to be canceled. We did see under the prior Trump administration, a proposed regulation was planned that would have eliminated the H4 EAD. That proposal never came out. It was never published. So they never went through the notice and comment period, which means they never actually finalized and published it. I would expect them to go through that process again and start that process. The regulatory agenda should be coming out in mid-February. That will tell us what each agency has planned for the coming 6 months in terms of regulation. So we'll have to see if there is an H4 EAD elimination regulation specified on there. Just because it's on the regulatory agenda doesn't mean it will ultimately go through as it didn't before, even though it was on the regulatory agenda. But with Stephen Miller being the one advising, he wants to limit legal immigration. He wants to limit who can get an EAD. This is probably meaning possible limits to OPT and STEM OPT, CPT, TPS, all of the different parole programs. So yeah, I think H4 EAD could be on the chopping block.
Do you see any pending H-1B extension approval issues for remote working people? We don't see that. Even though the government employees, they are forcing them to come in and work. And recently, as soon as, I don't know whether Trump has anything to do with it, Amazon started requiring everybody to come in. And there's this, in the Seattle, there is a traffic jam because of that. But as such, though, the government is not against the private employees to have the workforce in their remote. They will not force the private employers to have the workforce only in the office. It's only the government employees they're forcing.
DT says, is it still safe to apply for a change of status to B1, B2 if you're on H-1B and laid off? As of today, yes, it is. We are still able to do that. Going forward, the provision or the law that allows us to do that, all it was a simple update on the USCIS website. It's not even in the policy manual. It's not in a regulation. It's not in the statute. So it very easily could go away. But as of now, it is still an option.
Raghav has this question from YouTube. I got arrested, but the case was dismissed. Can I apply for citizenship? Any chances of denial? If you got anything arrested, though, I definitely request that you contact an immigration lawyer. We need to see what the arrest was, why the case was being dismissed. When the people say case is dismissed, though, it could be that you paid a penalty. You may have paid $50 as a fine, and then they dismiss the case. That's still considered to be conviction for the purpose of the immigration purposes. Definitely, if there is any arrest, though, we want you to go with a lawyer. Don't do it by yourself, citizenship application. PT has this question: why would the CBP officer ask us to show the email messages on the form at the port of entry? What are they looking for? They may be looking for fake experience. They may be looking for any fake experience resume that some people may have submitted. They may be looking into people who have worked illegally in the United States. For example, one guy who was coming on a student visa, he already negotiated with the gas station to work when he's first entering into the United States, so that as soon as he enters into the country, he can start working in the gas station. They found it in the WhatsApp message and they sent it. Could they already have that information before and they're just marking them at that point of time? Maybe, I don't know. But yes, there are so many instances where we have seen the CBP officer asking to open the emails, open the bank and show them the statements of the bank statements, also open the WhatsApp messages to see what's in there. We have seen that so many times. In fact, so many times, every week, 2 or 3 times, three people, we get consultation where people get deported. Out of those, 1 or 2 people are from Chicago airport. I don't know why. They do that more in Chicago airport than any other airport.
Arjun says, if the parents have an approved I-140, they are not considered as temporary for legal purposes. That is not correct. An I-140 gives you as the beneficiary no change in your legal status. It does not provide you with anything. Now, yes, can you use that I-140 to extend your H-1B beyond the 6-year limit? Yes, you can use that I-140 to get an approved H-4 EAD. but you're still temporary. You are still a non-immigrant visa holder. You do not gain any kind of benefit. So if you're thinking that because I have an approved I-140, this birthright citizenship mess doesn't apply to me, that is not correct.
Should I postpone my trip? I have a Dropbox appointment. This question comes from Venkata Nelapati. Yeah, I would, because if you're going for stamping, definitely there are more upticks in the 221Gs at this point of time. So definitely, if I were you, I would postpone it. One of the biggest problem that we face as an immigration lawyer in Trump 1.0 was definitely travel. Travel was the biggest problem for us. You go there, you get stuck. That's the main thing. Now, there are sometimes we force you to go because the H-1B extension get denied, I-94 expired. Now we have a consul processing approved. You don't have an option. You have to go. But the leisure travel is the one of the biggest problem that we have when we encounter Trump 1.0 travel. That is the problem that you can avoid it.
A couple of people have asked about the upcoming H-1B lottery. Are there any changes expected? Are they going to make it merit-based, salary-based, etc.? So the upcoming H-1B lottery, we will be submitting those registrations in the month of March, usually around the March 6th or 7th for a 2-week period. And then they run the lottery on March 31st and start notifying people. Those selected get to file between April 1st and June 30th. They've already implemented the changes to the lottery last year, making it a beneficiary-centric process. The only other change that was implemented last year but doesn't take effect until this year is the filing fee increases from $10 per registration to $215 per registration. Those are the only big changes. That is the only big change expected for this year's lottery, other than potentially minor changes about how we actually go through the online process and getting the handshake process electronically between the employer and the attorney and that sort of thing. It is too late for them to change anything to merit-based this year or salary-based this year. If they're going to do that, it has to go through the regulatory process. There's not enough time to implement that for this year, even if they did it as an interim final regulation. I do think we will likely see a proposed regulation. In fact, at the end of the Trump administration, they had actually finalized a regulation that would have changed the lottery selections and made it salary-based and whether you had a U.S. PhD versus a U.S. master's and those things. It didn't take effect before he left the office. And when Biden came in, he put it on hold and then eventually withdrew it completely. So there's already been a lot of groundwork laid for that. So perhaps we might see that in the 2026 March lottery, which would be for fiscal year 2027.
This question is coming from the Luck APT from Facebook. Can kids go to school if we change the status from H4 to B2 due to job loss and change of status pending? I don't see any problem in kids going to school if you have applied for B2 application at all. I don't see at all. The next question is it safe to go to Canada to apply for stamping for third country national? He's a Ukrainian. I don't see any problem in you going to third country national. In general, there is a problem in going for stamping, but nothing in particular at this point of time for you to go to Canada, especially when you are from Ukraine. Emily, this question is coming from Shruti Bhaskaran. What about the statement made by Trump that, hey, green card should be stapled to the degree?
Yeah, unfortunately, that was just his blustering during whatever event he was at. He is listening to Stephen Miller. You can tell by all of these executive orders. I don't see that happening. And it would require Congress to do it. And Congress seems to be anti-immigrant all of a sudden, even the Democrats, with the way the Lake and Riley Act went through with Democrat support. I don't think that's going to be happening. One question came up about applying for the blanket L renewal at the consulate in March. Is that a good idea? For my companies, I'm letting them know that there is a chance of travel ban. which could lead to their employee getting stuck outside the US. So you have the other option, which we don't normally like, but it's filing an extension with USCIS that's under the blanket. So the company files both an I-129 petition and an I-129S under the blanket. USCIS is technically in convincing that you're eligible for this visa. USCIS is just reasonable that you meet all of the requirements, 50% basically. But when you file with USCIS, it's a much higher standard, very high chances of request for evidence, even though you've already been issued a blanket visa by the consulate. They don't care what the consulate did. They're looking at it with fresh eyes. So high chances of request for evidence, but ultimately you can get the approval and not be subject to a travel ban. So a lot of my companies are opting to file the extensions with USCIS, even though it's likely going to take longer and cost more money and more hassle factor.
Sai is saying that he's an H-1B and his wife is a dependent expecting a baby next week. How will the executive order affect him? Since the baby is expected next week, though, the executive order is becoming effective on February 19th. That's almost a month right now, so I don't see any problem for your baby to be automatically U.S. citizen. One of the gentlemen, one of the person, Ramya, is making the statement that they have seen a USCIS alert now stating that they will adjudicate H1 and H4 and EAD if filed together properly. We didn't see any of that. That was an agreement with Eduki, and that expired on January 18th. So, and in fact, we spoke with the lawyers, and they said they are not going to extend that. They're not going to extend. That's what they said. It could be the statement that probably came out, and when the settlement was done and the court settlement was done, nothing recent one though. In fact, we've been told they're not going to honor going forward.
A couple of people have asked about stateside visa renewals, the domestic stamping program. What's the status of that? Will it be implemented this year? So I think everybody liked the pilot process, and there was a post on the U.S. Consulate in India's website, and it was kind of hidden in another post mentioning that they do plan on implementing that, expanding it. That being said, that was before the Trump administration, so I don't know if it will be delayed due to the change in administration, especially when we're talking about all this extreme vetting, and the stateside renewal process does not include any kind of interview component. So it may be put on hold. We'll just have to wait and see. But there's no rumors on that other than the most recent update was that they planned on implementing it further.
One of the person who has an H-1B, which is not stamped, but has an EAD in advance parole, when they went for the H-1B stamping, they got the 221G. Can they return back an advance parole? I would definitely recommend to consult a lawyer. There is a chance, definitely. You don't have to clear the 221G. Since you have an advance parole, you can, but I still will strongly recommend that you consult an immigration lawyer before you do come back into the United States, especially with the new administration and extreme venting going on right now. One proposal that I would give is that if you have an H-1B or H-4, though, if you have an advance parole, why did you even went for stamping? You could have just come back into the United States. You could still have been considered, the H-1B is still valid if you come back into the United States. That's a bad thing you did it.
Travel Science says, are there chances of the H-1 application fee to be increased? Yeah, I do think so. We do have the registration fee increase already taking effect this year. USCIS does generally increase their fees every couple of years to keep up with inflation. They just did a fee increase April of last year, so maybe next year we might see another fee increase. But I would definitely expect some of these different bills that are making their way through Congress, whether it has anything to do with immigration or not. There are congressmen and senators that are kind of sneaking in provisions that would require additional fees. For example, one of the senators during the Lake and Riley Act passage, there were 96 amendments that were proposed for that. They only considered 2 of them, but of those 96, one of them, I think it was from Bernie Sanders, would have required higher filing fees for H-1B petitions, a special scholarship fund to be created through the National Science Foundation as part of those filing fees. So yeah, that's definitely on the table. Just given the current political issues regarding H-1Bs right now.
Emily, this question is coming from a gentleman from YouTube. Bharat Vyas is asking the question, will the state gives birth certificate with the executive order though? I think so. He has some very validity though. Some states may give because they may say, hey, according to the Constitution, he is a citizen, so I don't have to go with the executive order. Here is the birth certificate for you. But then comes the question about the passport, which comes under the federal government. The federal government definitely will not issue unless the court sides with them. If the court is dilly-dallying on that thing, we may see some states issuing the birth certificates, some states not issuing the birth certificate. I can say that then it also depends on the city though. For example, it's in Texas, it's the cities that issue the birth certificate, not the state. Then Houston may be different. The small cities may be different. What do you say?
Yeah, I could easily see some of the states deciding that, well, they're not citizens anyways. Why do we need to give them birth certificates? They're not subject to our jurisdiction. I could definitely see that happening. Hopefully, this will be enjoined before we get there, but we're definitely going to see just a big legal mess from this
executive order. It's going to be states. Some of the states will be doing something. Some of the cities will be doing something. Eventually, this will have to be sorted out in the federal court, though, in the Supreme Court. Not just this will go to the Supreme Court. Do you have any doubt that this will not go to the Supreme Court, Emily?
No, I'm sure it will.
Okay. What does extreme venting means? How does it affect the port of entry for valid visa people? Well, let's say you're coming on a non-immigrant visa and they're going to go through everything. Okay, you came into the United States now in the CBP. How long does it take for you to enter into the United States? You go there, you present the passport, they look into the things. At the most, they may ask you pay stubs and they may ask you some bank statements, and that's allowed. They'll come into it. What if they say, no, we want to see the income tax returns. We want to see every month that you work, the pay stubs that you work. We want to see all the bank statements that you have done. We want to see the lease agreement, where you stayed, whether you complied with the LCA agreement or not. When you're an OPT, we want to see all the places that you worked. Do you have an experience letter from each and every place that you worked on? That is considered to be called extreme venting, according to me. I mean, that's just one example of it, though. I mean, there could be all different things that they may say, hey, your degree certificate is from Usmania University. Does it exist? Is this a real degree? Okay, let me do one thing. Let me detain you while I verify whether this is a real degree or not. You'll be in detention until they determine the degree is from Usmania University or not, which may take 15, 20 days. That is considered to be extreme venting, what I meant, what probably Emily meant. So they are, if they want to do it though, they have a lot of different things. I cited only 2 of those things. You may not have all these documents with you, which I stated with you right now. You may not have, how do you prove the authenticity of the Usmania University? You have an original document. And how do you prove the authenticity of that thing? I mean, they have to go to they will say, no, the original is not good enough. You need to go speak with the Usmania University registrar. That is extreme venting. That will delay your port of entry. That will delay everything.
Tyson from Facebook says, I recently transferred my H-1B visa, considering traveling to India for visa stamping. Previous visa expired in 2023. Is this a good time to travel, Or are there any issues or delays I should be aware of? No, it's not a good time to travel. Because you don't have a visa stamp, there's a possibility that once you leave the country, some sort of travel ban gets implemented, some sort of block on H-1Bs gets implemented, and you're not able to get the stamp and have no way to come back. That happened to a lot of people under the previous travel ban. On top of that, even if there's no travel ban, as Rahul pointed out, all of the things they can do with extreme vetting. So your visa stamping itself can require a lot more documentation, have them look into everything, review everything, ask for all these documents, and then administrative processing on top of that, make you sit there waiting for weeks and months for them to go through and check everything out. And then by the time you get the visa, you've lost the job. That happened time and time again during the previous Trump administration. So now is not a good time to travel.
Post-industrial economy has an interesting comment what extreme venting means. He says Trump will be asking about questions about computer science things, basically trying to detain for every reason. Yeah, you may be right on that thing. You may be right. And what about level of jobs? What if you're making 150K and then you say, hey, that's level 3, you should be at level 4? Or what would they say? Hey, they're paying you level 3 job and you're only doing level 2. Who knows? These are all the different things that extreme vending means. And when I looked into the executive orders, though, even though they may not directly applicable to the non-immigrants, other than this birthright, but indirectly they may affect it. Overall, this administration is against non-immigrants. So those people who are legally paying taxes, those people who are legally staying in the United States, those people who are getting prevailing wages, and most of the salaries that I see of the H-1B L1 is way higher than the normal wages I see for the American worker. Still, there may be an extreme venting against those people who are legally present, legally paying taxes, legally staying in this country. This administration is not good for us at this point of time. Yes, we have seen Trump 1.0. We have to have patience. And as the problems will arise, we as immigration lawyers will try to find the solutions as the things go. Yes, we have seen from 2016 to 2020, it took a while for us, but starting from about 2018 or 19, we started finding the solutions, going to the courts, getting the decisions in our favor. So it is not going to be a good time for sure. Some tips that I would suggest you at this point of time is try to avoid travel. If you have any non-immigrant visa, let's say if it is expiring in May of 2025, get it adjudicated before May of 2025. Let's say your H-1B is expiring May 2, then you get in premium processing, get it approved by that time. If by any chance you get denied, you get a chance to file one more application. These two things, if you follow, you will try to avoid a lot of different problems. Yes, I want you to be well educated. At the same time, don't be don't go to fear mongering people. Oh, they are coming and they're attacking and all those things. Try to listen to the YouTube channels that are more accurate, that are practicing. And I would say that we are one of the very good. Please try to like our channels, subscribe to our channels, and do frequently come to us every Tuesday. We do bring in live updates. This is not the first time that we are doing it. For those lot of people, newcomers that I see, we've been doing this for years. Every Tuesday at 5 to 6 p.m. we take live questions, and we are immigration practitioners. We practice immigration law. We are not just YouTubers. So.
Yeah, another question that popped up from Venkat Ramnath, will H-1B extensions or amendment rejections raise with this new government that came to power based on past experience? Yeah, definitely. Especially under the prior Trump administration, he eliminated the deference memo. That memo previously said that if USCIS approved you once, if you file the same thing again, same job, same work location, same company, all of that, they should defer to the prior approval and just approve this next one unless there was some sort of gross error in that approval. That was the law of the land for 20 plus years. And then Trump eliminated that memo, and all of a sudden they were questioning everything. You could have been in the same job for 12 years, had 4 different H-1B extension approvals, and now all of a sudden they're saying, we don't think your job is a specialty occupation. So yeah, definitely RFEs went from, I think, 3% to 30%, even for extensions. Denials greatly increased. So even if they don't eliminate the deference memo, I haven't heard anything about that. Maybe it's likely, maybe it's not. We can definitely expect higher rates of denials, even for people who have been here for years, for extensions, for amendments, everything has a chance of higher rates of denials, higher rates of RFEs.
Okay. Anything else, Emily?
I think we are good for today. We did go a little bit over since we had a lot of people joining and asking questions. We will be back next Tuesday live, and we do, as Raul said, recommend that you subscribe to our channel because we do go live whenever there's any kind of breaking news that legal immigrants, high-skilled immigrants should be aware of. And during the prior Trump administration, that was quite common, especially on Fridays. And so we do want to keep you updated, and you would get notified if we're going live on any of those. But please join us next Tuesday as we will see where we stand on any changes that come in going forward.
Thank you for tuning in.